Bill Henshaw here, your constitutional counselor from the San Francisco Peninsula, still on an extended stay in Iowa, doing some serious damage out here that you may actually read about in the mindless mainstream media before too long. But that said, the topic for today's video is going to be a revisiting of traffic court. And haven't we all been there? I have too. Back in the day, so that's how I got started out with this, with a traffic arrest, and I got thrown in jail for the weekend back on Valentine's Day, 1983, which I call the latter-day Valentine's Day Massacre. That's what got me started on the track to get where I've gotten to today, where I have a portfolio that's unbelievable, and I'm blessed to have it. I've got a lot of help from upstairs. Thank you very much for that. And oh, by the way, I'm looking for investors with investment capital and that can hook me up with people that'll be interested in doing what I'm doing, celebrity types, and we'll go from there. That's not the point of this video, but in any event, send me an email, youwinnincourt@gmail.com. That traffic court is just as ridiculous as you think it is. And by getting my modestly priced constitutional defense document packet, you can learn exactly why. I mean, for openers, that's nothing remotely resembling a judicial court to which we have the right from day one. It's not there. It's not neutral. It's anything but neutral. All you have there are state bar association attorneys, even the public pretender, who's not going to put in any of the issues that I advocate, unopposed issues, even if he knows them, and he probably doesn't. We don't teach him a damn thing in law school these days. And I never went to one, oh, by the way. I learned it all on my own. But it hasn't been any serious law school stuff for the last at least 60 years, and maybe closer to 80, back when Rehnquist and O'Connor, justices on the court together later, were also at Stanford University together. And they taught some of this stuff in the 1940s, not now. I remember when I first came to California, I was out there in Oakland, and I spent a lot of time at the law library at UC Berkeley, fifth largest law library in the country, before we had internet and all that. And one reason that I packed away as much as I have, and it's more than memory, it's perspective. That's what I want to teach you, not just knowing what it is, being able to put it all together. When you start to be able to do that, you get really dangerous. Now that's the good news, and you can learn how to do it. Send me an email, youwinnincourt@gmail.com, and I will teach you how to do that, particularly in traffic court. And you can throw in the Child Procurement Agency, Inc., among others, that you can do the same thing. They don't have any more jurisdiction than the traffic court, the criminal court, or anybody else. And we can prove all of it, and with attitude and with authority. So you get in there, and for example, like the law says in California, quote unquote, probably typically across the country, that no person shall drive a vehicle of the type to be required to be registered unless he has a license issued under this code. Wow, the magnitude of the problems. Person, quote unquote, which should be in capital letters. That means a corporate entity. And they should have a very hard time confusing you with Chase Bank and IBM, don't you think? But that's all they have, corporate entities. That's the 14th Amendment BS citizenship, which is all that quote unquote state constitutions recognize anymore. So they should know right away charges shouldn't even be filed, and they should be dismissed by a neutral magistrate without even you having to do anything. Anyway, no person shall drive, and you drive a team of horses. All you have to do is look at the logo on the Teamster Union, and you'll see exactly what that is. Of a type required to, or a vehicle of a type required to be registered. And a vehicle is one that's engaged in interstate commerce. The Supreme Court has ruled that that's in effect, well, I can't think of the word right now. It's in effect admiralty and maritime jurisdiction. And no state court can exercise that. That was the central cause of the American Revolution, for crying out loud. And here we are back today in these damn admiralty courts, aka administrative tribunals. Can't do any of it, and they can't prove any element of those crimes that I listed before. They simply can't do it. And among other things you get when you get my modestly priced document package is a bill of particulars, 14 pages from hell, they can't answer 2 paragraphs, yet the Supreme Court has ruled in a case, interestingly enough, called Coffin, Coffin, the United States. I don't remember the full site right now, but it was decided in the 1890s, long after the 14th Amendment. So it couldn't have been modified or destroyed by that amendment now, could it? And that amendment doesn't exist. Coffin does, and the Supreme Court's telling them, DA, you have to answer. If you don't, then we go for a writ of quo warranto. On what authority? And a neutral magistrate that we're supposed to have there sitting there in a black robe is supposed to dismiss that and really do it sua sponte on his own motion. Because think about that. We get in there, we don't know the nature and cause of the accusations, where the hell we are, how we got there, what the rules of the game are. My goodness. So how are we supposed to put on a defense, know what they have to prove? And the key point here is that these traffic crimes rarely, if ever, have any injured party. Haven't they ever heard of the uncontested right of confrontation and cross-examination? Where did we waive all of these rights? And think about this too, when we walk in the front door of the courthouse, we're presumed incompetent from day one. If we're incompetent, how could we make a voluntary, knowing, and intelligent waiver of rights? That's the Supreme Court reference standard. I'll get the case for you in a sec here. I know it. I just can't think of it right now. But Johnson v. Zerbst, 304 U.S. 458. So if we haven't made any voluntary, knowing, and intelligent waiver, in addition to the fact they never have made a full disclosure to you at the time you entered the agreement, whether it was an application for a driver's license, social insecurity benefits, a marriage license, you name it. And oh, by the way, license, Black's Fourth Law Dictionary, think about this one. Definition is permission granted by competent authority to do an act that without such permission would be illegal. Whoa, wait a minute here. Aren't we in a principal and agent relationship with these bastards? Didn't the framers ordain and establish this Constitution in order to secure the blessings of liberty to ourselves and our posterity? What the hell has happened here? And you will learn all about that in detail. Order my modestly priced document packet, and you'll learn all of it here, exactly what's going on, and be able to go into court and do what it is I do, stop them dead in their tracks. And that's my job, by the way, to teach you. So with the document package, you get some complimentary phone consultations and even a complimentary Zoom appearance at a contested hearing. But I teach you, especially with the 5 basic documents, what they are, how to use them, and what they mean, and give you perspective a lot quicker than I got it. Those are really powerful tools, and you can pass those on to your children and your posterity and let them do the same thing. So, that really is, when you think about it, it's amazing, but you just have to learn what the words are, what they think they mean, as opposed to what the Constitution thinks they mean. 2 completely different things, but they know it. Better yet, the justices on the U.S. Supreme Court know everything I've just said here and more besides. They're going to have our back. First time in 90 years. That's exciting. For more information, send me an email, uwinnincourt@gmail.com. Remember to subscribe, like the videos, tell your friends, get the word out. Thank you.